Mic check 1, 2, 3. Good morning, everyone. The time is 9:15. This is the first captions check for our stream online. As a kind reminder to everyone in the room, if you are speaking today, please make sure that the light is on the microphone. And before you leave the podium, please make sure to mute the microphone for the next speaker to follow the process, as I'm about to do right now.
It's funny to my eye. Nothing about the light changed when I. Yeah, but
Good morning, everyone. We're going to get started here shortly. Just wanted to do a final mic check. Mic check, 1, 2, 3. Okay, one can hear. For those in the room, if you're going to speak today, please make sure that the light is on the microphone. And before you leave the podium, please make sure to mute the microphone as I'm about to do right now.
We'll get started in just a minute, just sorting out some technical difficulties.
Did we have a separate motion? I'll be able to remember that and find it now with this message. Can you forward it to the This is
Not working. Yeah. You got it? All right.
It's not that it's probably giving solutions.
That's good. This is green, right? Okay. All right, here we go. Good morning, everyone. It is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, September 25th, 2024. The time is 9:33 a.m. With us today are Commissioners Bobby Chineka and Katarina Gonzalez, as well as our General Counsel, Mary Smith, and I'm John Neerman. Registration has closed, but if you'd like to address the Commission on a particular item, I'd ask you to please visit our registration table or email agenda@tceq.texas.gov. Include your name, your affiliation, and the item that you'd like to comment on, and we'll do our best to accommodate that request. For anyone addressing the Commission, our General Counsel or I will inform you of your time limits and let you know when it's your turn to speak. Thank you, everyone, for being present today. Ms. Smith, please call the first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the petition for the creation of Duck Creek Municipal Utility District of Denton County. The parties may present in the following order with the following time. Petitioner, 8 minutes. Protestants collectively may have 8 minutes. ED, 5 minutes, and OPIC, 5 minutes. The petitioner may reserve time for rebuttal as it bears the burden of proof in this matter. So with that, we'll begin with the petitioner. We have James Ruiz with Winstead PC.
Good morning, Mr. Ruiz. Just make sure you've got a light on.
I do have it. Thank you.
Great.
Morning, Chairman Neerman, General Counsel Smith, Commissioners, TCEQ staff, and OPIC. This was a case where there really wasn't much opposition to it. The protestants really just wanted an opportunity to air their concerns, which are real to them, and then also, some of their apprehensions. And basically, they didn't submit any evidence to refute the fact that the applicant does meet all the statutory and regulatory requirements for the creation of the MUD. And for that reason, I just soon reserve my time. And if we don't hear anything, then give it back to the commission. I know y'all are busy.
Thank you. Thank you, Mr. Ruiz.
For the protestants, we have Deva Prater, and I'm sorry if that's an incorrect pronunciation of your name, for the SIPs, for Christina SIP.
Ms. Prater, are you there? Are you with us virtually? All right. Let's hear next from Executive Director staff.
Good morning, Chairman, Commissioners, General Counsel, and Office of Public Interest Counsel. My name is Kayla Murray, and I'm an attorney in the Environmental Law Division representing the Executive Director. With me is Justin Tack, Manager of the District Section. Except for the minor changes recommended by the ED and her exceptions to the PFD, the ED recommends the Commission adopt the Administrative Law Judge's proposed order and create the district. In the proposal for decision, the ALJ concluded that the applicant met its burden of proving the district's creation meets all applicable statutory and regulatory requirements. Therefore, the ED recommends that the Commission grant the petition and create the Duck Creek Municipal Utility District. Thank you, and we are available for questions.
Thank you, Ms. Murray. I have none. Any questions, colleagues? All right. Mr. Wayne, good morning. What's the view from the Public Interest Counsel's office?
Hey, yes. Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. With respect to the Commission's consideration of the proposal for decision and related record in this matter, after participating in the hearing on the merits and examining the evidence and the argument presented, OPIC agrees with the Honorable Administrative Law Judge that the petition should be granted. OPIC finds that a preponderance of the evidence shows that petitioners have met their burden of showing that the creation petition and supporting documentation meet all applicable legal requirements, and that the district project is feasible, practicable, necessary, and further would be a benefit to the land to be included in the district. Despite this, OPIC continues to take issue with one discrete aspect of the proposal for decision concerning the allocation of transcript costs among the protestants. It recommends that the division of reporting and transcript costs be 50% to the petitioners, 25% to protestant party, the Rushings, and 25% to the 6 remaining protestant parties as a group. While not taking a position on the proposed overall 50-50 split between petitioners and protestants, OPIC has concerns that the specific allocation of 25% to the Rushings is not equitable and could have an unintended chilling effect on public participation in future hearings. It could also be seen as a punitive measure that effectively punishes the Rushings, which does not appear to be the intent of the assessment of transcript costs. Again, while not taking a position on the split between petitioners and protestants, we propose that if protestants are to be assessed transcript costs, an equal split between all protestant parties would be more equitable. With respect to the proposal for decision, it generally concluded that protestants' opposition to the district has caused months, if not years-long delay and increased costs for petitioners. And it found specifically relevant to the Rushings that their conduct at the hearing on the merits crossed the line from a good faith attempt to participate in the legal process and became misuse of the SOA proceeding. While OPIC does not discount the importance of proper courtroom decorum, we respectfully submit that this allocation is not warranted under the specific circumstances of this hearing. First, we observe that delay is not a required consideration under the relevant factors. In our view, general delay caused by mere participation in the legal process lies outside the scope of the inquiry when deciding how to assess reporting and transcript costs. To the extent that delay is considered, it is more properly narrowly focused on the length and delay of the hearing on the merits where the actual cost of the transcript is generated. Here, the hearing on the merits both convened and concluded the same day, indicating that no significant delay occurred. Further, to the extent that the administrative law judge found conduct at the hearing on the merits to be disruptive, it may have been properly addressed at that time under Commission Rule 30, Texas Administrative Code 80.11, which governs conduct and decorum and violations thereof at contested case hearings. In sum, OPIC is supportive of the public's exercise of its right to participate in commission processes to the fullest extent possibly authorized by applicable state law and commission rule. To that end, we are concerned that this consideration of conduct at the hearing on the merits when allocating costs could have an unintended chilling effect on public participation in hearings in the future if it were to become commonplace. Commission matters such as district creations are quite often complicated and technically dense, and it is our hope that laypersons may be forgiven for what may be inelegant attempts at questioning and occasional forays into topics of dubious relevancy. Because of this, OPIC respectfully recommends that the Commission grant the creation petition and modify the administrative law judge's proposed order consistent with these discussed recommendations regarding the allocation of transcript costs. Specifically, we advocate for an equal split between all protestant parties. Thank you, and I'm available to answer any questions that you may have.
Thank you, Mr. Wayne. I have none. Any questions, colleagues? All right, seeing none, let's go back to Ms. Prater, give her an opportunity to.
I understand she's trying to log on to the
Okay.
webinar and having some difficulty.
Okay. Well, let's give her a minute then. Continue the item. Mr. Ruiz, did you have anything you wanted to offer in rebuttal?
Yeah.
Okay, I didn't hear anything, but needed to check. Colleagues, I am, generally aligned with the ALJ's proposal for decision. There are some changes that I would recommend for clarity mostly. I have put together a change document that outlines what those are. It's fairly self-explanatory, but wanted to gather your thoughts before I circulate that on the matter generally, also the issue about transcript costs, and go from there. Commissioner Janeka.
I'm prepared to move forward with the matter as the ALJ has sent it to us, but I think I am receptive to OPIC's arguments on transcript costs and would be open to discussion on that.
Appreciate that. Commissioner Gonzalez.
I agree with that. I generally agree with the ALJ's proposed order.
Okay. Ms. Prater, I understand you're there now. Do you want to offer the commission your thoughts? Ms. Prater? All right, let's do this. Let me circulate this change document. And on the chance that we're able to get Ms. Prater, I will not recess. I'll just let you review the document and we can discuss it on the other side.
So I understand that Ms. Prater was muted while you were talking, and so I've asked, let's see, I'm asking the chief clerk's office to unmute her and see if that allows
Okay.
her to speak.
Yep. Ms. Prater, are you there? Yeah, they'll kind of sort that out. Ms. Prater? Well, colleagues, what do you think? Commissioner Janeka?
I'm always loath to close the door to our process, but I'm prepared to move forward and move on to the other items if you want to delay this one, delay to it, get to other items and get back to it. I'm almost as reluctant to add confusion to our record before the public in terms of our decisions.
So I'm gathering you're fine with the change document.
I'm sorry, yes. Starting with the change
Should I
document.
distribute that to the parties and
Please.
allow?
Yeah.
So, Marielle, if you would distribute that to the parties, and I'll ask the chief clerk's office to also post the change document on the webinar.
Commissioner Gonzalez, your thoughts on the change document?
I'm good with the changes in the change
Okay.
document.
All right. Ms. Prater, are you there? Colleagues, I think we just need to get on with our business. I'm going to go ahead and read a motion and invite any discussion on the other side. Colleagues, I move that we grant the petition for the creation of Duck Creek Municipal Utility District of Denton County and the addition of road powers under Texas Water Code Section 54.234, that we appoint Anthony Heinze, Ashley Reeves, Charles Butler, Glenn T. Carlton, and Randall Smith as temporary directors, and that we adopt the administrative law judge's proposed order with the changes set forth in the document I circulated today. Is there a second?
I'll second that.
Any discussion? All those in favor say aye.
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 Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of USA Waste of Texas Landfills Incorporated for MSW permit number 2185A. Presentations will begin with the applicant, followed by the protestants, the ED, and then OPIC. The parties have been notified that they will have the following time: applicant 9 minutes, protestants 9 minutes collectively, and the ED and OPIC will each have 5 minutes. The applicant may reserve time for rebuttal as it bears the burden of proof on its motion to withdraw without prejudice. And so we'll begin with the applicant. I believe we have Mr. Brian Moore.
Good morning, Mr. Moore.
Good morning, Chairman. Good morning, Commissioners. Good morning, General Counsel. We filed a motion to withdraw our application without prejudice under Section 80.25E2 of your rules. Harris County, Hope Healing and Hooves, and Westwind Industries, 3 protestants, they submitted requests for reimbursement of their expenses that they claimed that they incurred, quote, in the permitting process. We have paid Harris County's reimbursement request in full. just last Thursday of last week, Hope Healing and Hooves finally provided documentation confirming that it has actually paid the expenses for which it seeks reimbursement. So now, per the administrative law judge's recommendation, we will reimburse Hope Healing and Hooves $5,158.14 for their reimbursable expenses. That leaves us only the unresolved disputes concerning the reimbursement request that was submitted by West Wind Industries. Those unresolved disputes have been briefed extensively. First in the briefing on our motion to withdraw our application, then again in our exceptions to the administrative law judge's proposal for decision. In her August 13th letter responding to our exceptions, the ALJ construed our exceptions to be the same arguments that we made in support of our motion to withdraw our application. And because of that, in her letter, the ALJ concluded, quote, because those positions have already been addressed, the ALJ recommends that no changes be made in response to the applicant's exceptions. We understand that. However, our exceptions also concerned two issues that arose in the first instance upon issuance of the proposal for decision. And both of those issues, both of them, concern West Wind Industries' reimbursement request. The first issue is that the proposal for decision recommends that we be ordered to reimburse West Wind for $10,000 more than what West Wind claimed in reimbursement. The ALJ closed the record in this case on April 15th. The very next day, on April 16th, West Wind filed its status report claiming that it is due $416,000, and I stress $16,000, $416,535.36. However, the ALJ's PFD recommends that we, the applicant, be ordered to reimburse West Wind $426,000. Well, of course, we flagged that $10,000 discrepancy in our exceptions to the PFD, and we assumed at the time that that was just a typo and that that typo would be corrected by the ALJ once it was brought to her attention. But again, the ALJ's letter responding to our exceptions is silent on the issue. And for its part, West Wind has only compounded the confusion. In its brief responding to our exceptions, West Wind now demands that we be ordered to reimburse them $425,535.36. Well, we can all do the math. That's $1,000 less than what the ALJ recommends and $9,000 more than what West Wind itself demanded at the close of the record. Now, we have significant substantive issues with West Wind's reimbursement claim. And of course, we take the position that West Wind is not entitled to the full amount of its reimbursement claim. But I hope that we can all agree that West Wind is not entitled to $10,000 more than it even requested. Now, our significant substantive issues with West Wind's reimbursement claim, that brings us to the second issue that we here again raised in our exceptions, but that is not addressed by the ALJ in her letter. By far the most substantive dispute that you're going to have to resolve today is whether West Wind is entitled to reimbursement for the $157,500 in monthly salary payments that West Wind claims to have made to Bill Huntsinger. Mr. Huntsinger is a contract employee who does not have a written contract. In her PFD, the ALJ reasoned that the Commission's Rule 80.25, quote, does not provide authority to analyze the wisdom of the payments to Huntsinger. Well, in our exceptions to the proposal for decision, we responded directly to that assertion. The entirety of Part 3 of our exceptions to PFD was devoted to the Code Construction Act and its proclamation that a just and reasonable result is intended with each rule that is adopted under a state code. Because 80.25E, the rule that we're here about today, was adopted under the authority of both the Water Code and the Health and Safety Code, application of the rule to West Wind's reimbursement claim must yield a just and reasonable result. And as we set forth in our exceptions, it would not be just and reasonable to require applicant to pay Huntsinger's salary as a de facto employee of West Wind. It was not just and reasonable for West Wind to shield Huntsinger from expert discovery for the entirety of the case. And it is not just and reasonable for West Wind to claim that Huntsinger performed work as a, quote, consulting expert for months after this case was abated, after the applicant filed its motion to withdraw its application, and after the ALJ ordered the record closed in this case. It is not just and reasonable for West Wind to claim that Huntsinger performed consulting services when there was no further litigation anticipated, when there was no trial preparation ongoing or any prospect of trial. Per Rule 192.7D of the Texas Rules of Civil Procedure, a consulting expert is, quote, an expert who has been consulted, retained, or specially employed by a party in anticipation of litigation or in preparation for trial. West Wind's reimbursement claim includes full monthly salary payments to Huntsinger for the months of November and December of 2023 and January through April of 2024, despite the fact that the case was fully abated on November 15th. That abatement was never lifted. While the case remained in abatement, applicant formally moved to withdraw its application on January 11th, and the record was closed in this case on April 15th. West Wind is seeking reimbursement for salary payments, full salary payments made to Huntsinger for 5.5 months when the case was fully abated, when there was no trial to prepare for, when there was no active litigation, and when there was no legitimate role whatsoever for a consulting expert. Thank you for your time.
Thank you, Mr. Moore.
We have Ernest Wotring for Harris County.
Good morning, Mr. Wotring.
Good morning. Good morning, commissioners. Good morning, general counsel. Good morning, staff. I think this will be brief. I represent Harris County in light of the statutes, in light of the motion that has been filed by USA Waste to withdraw the application. Harris County stands in favor of the proposal for decision at such time as the terms and conditions stated in it are met. That's really all, the entirety of my presentation. I'm happy to answer questions or return the time back to the commission.
Thank you. I have none. Colleagues, any questions? I think we're good. Thank you, Mr. Wotring.
We have Blair Pena for West Wind Industries.
Good morning, Ms. Pena.
Good morning. Good morning, commissioners. Good morning, general counsel and staff. My name is Blair Pena, and I represent West Wind Industries. We're here today in support of the ALJ's proposal for decision requiring full reimbursement of my client of $426,000
$426,535.36, which is the amount listed in the proposal for decision, as expenses that were incurred by my client during the quote-unquote permitting process, which is still ongoing today as apparent by our appearance today. This is a condition to dismissal without prejudice under the Rule 80.25. While the applicant has promised to reimburse at least undisputed amounts since January, to this day and standing before you, we haven't even been reimbursed the undisputed amounts. Because of this delay, we would ask the TCEQ to consider entering an order requiring reimbursement within 3 business days of today's meeting. Now, in looking at Rule 80.25, there are really 3 requirements to entitle us to reimbursement. First, it can't be for attorney's fees. Second, it has to be incurred in the permitting process. And third, they have to actually have been paid. My client, Westwind, met this standard. And as you heard, the applicant is only complaining about one item, Hunsinger Consulting, or HC. But when it comes to HC, it's undisputed that he's not an attorney. It's undisputed that the services were incurred as part of the permitting process. Specifically, the evidence that we submitted talked about how Mr. Hunsinger was involved in selecting and hiring legal counsel, coordinating the community outreach, reviewing documents, and participating in countless legal strategies. It's also undisputed that my client actually paid these fees. Now, what the applicant came up here and told you was a bunch of argument, but they didn't submit any evidence to suggest that Mr. Hunsinger was anything other than an independent contractor. To be clear, he is not an employee. He is an independent contractor. And this monthly retainer, as I'm sure you all recognize, ensure that his services are available and that he doesn't get taken away to perform work on other projects. The rule, as it's written, does not require certain qualifications in order to be entitled to reimbursement. And despite the fact that Mr. Hunsinger is not an engineer or a geologist, he does have real-world experience in protesting landfills. Specifically, Mr. Hunsinger was the former president of the Citizens Against the Landfill in Hempstead, which led the protest of the Pentel landfill and was successful in their opposition on not once, but 2 occasions. Mr. Hunsinger was clearly the man for this job. Additionally, the rule does not require written agreements in order to entitle protestants to be entitled to reimbursement. It doesn't prohibit flat fees. While the applicant has a problem with this, we like to believe that some people still see the honor in a handshake deal. Additionally, when it comes to this just and reasonable argument, Mr. Hunsinger's fees are reasonable. The commission referred over 20 issues to SOA to be decided. The applicant produced over 78,000 pages of documents in response to our request for production. If Mr. Hunsinger spent 1 minute looking at every one of those 78,000 pages, that's 1,300 hours since he was hired to protest this landfill. That's a significant amount of time in just reviewing documents and doesn't take into consideration the strategy sessions and everything else that goes into preparing a proper protest. The policy behind section or rule 80.25 supports full reimbursement of my client. And that policy and this rule was put in place to compensate the non-initiating parties for the resources that they've expended to participate in a process that failed through no fault of their own. Mr. Moore would like to complain about things that were hidden or things he didn't know, but you have to remember it was the applicant who decided to withdraw their application without prejudice before completing discovery. If they had taken my client's deposition, they would have all the answers that they claim they don't have today. Another policy of this rule is to prevent applicants from depleting resources of opposing parties by forcing them to incur expenses over and over and over again for the same application. By seeking to withdraw this application without prejudice, that implies that they intend to refile their application. They've only pulled this application because it was shoddy to begin with. And it's no coincidence that they pulled their application right after losing 2 times our motion to compel a site visit. The applicant did not want us out there. The applicant did not want Harris County out there. We had intended to do extensive soil, air, and groundwater testing. And when the ALJ compelled it a second time, days later, the application was withdrawn. The protestants should not be punished. That's not good public policy. We didn't start this application, and we didn't decide to pull it. And there is no evidence here before you in this record that would suggest that anything else would be unjust or unreasonable. The only answer here is to grant our request in full for the full amount determined by the ALJ. One point of clarification on the numbers. Mr. Hunsinger was agreed to provide services for a flat fee. The numbers we initially provided to the ALJ were only through January. I believe the additional compensation came in because the record did not close until April, and my client didn't quite know what was going to happen. My client didn't know if the applicant
That's
was going to
7
reverse
minutes.
course again.
Just complete your thought if you would.
Well, in conclusion, we would ask that you all accept the ALJ's proposal as it's written, overrule all of the objections, and require full reimbursement of my client within 3 business days of any order that you all enter. I'm available if y'all have any questions.
Colleagues, any questions for Ms. Pena? I'm confused about the 416 versus the 426. When I look at the record, I'm finding 416 and change. What's the extra $10,000?
So the 416 included the invoices for Hunsinger Consulting through January. We figured February, March, and April, approximately it was $5,000 per month that he was being paid. And we believe that the ALJ compensated Westwind for the additional months until the record closed from the date that we submitted the original information.
Okay, thank you.
You're welcome. Thank you all.
And I believe we don't have anyone signed in for Hope Healing and Hooves, but I'll just confirm that. No one is stepping forward. So then that brings us to the ED.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Office of Public Interest Counsel. I'm Anthony Tatu. I'm a staff attorney with the Administrative Law Division, and with me today is Megan Henson from Waste Permits. We're both here this morning on behalf of the Executive Director. The Executive Director supports the proposal for decision that was issued by the Administrative Law Judge and respectfully recommends that the Commission adopt the proposal for decision and allow the applicant to withdraw its application without prejudice, assuming that the applicant reimburses the other parties in this case, consistent with 30 Texas Administrative Code, Section 80.25. And we will be available for any questions you may have. Thank you.
Thank you, Mr. Tatu. Colleagues, any questions? All right, Ms. Jamison.
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jennifer Jamison on behalf of OPIC. OPIC respectfully concurs with the findings of fact and conclusions of law as outlined by the ALJ's proposal for decision and supports dismissal without prejudice, provided that all reimbursements have been made pursuant to 30 Texas Administrative Code, Section 80.25. OPIC notes that as of today, our understanding is that not all parties have been fully reimbursed, and accordingly, applicant may not currently qualify for dismissal without prejudice under the conditions required by Section 80.25. Thank you, and I'm available for questions.
Thank you. Colleagues, any questions? All right, well, just to nutshell this, Mr. Moore had me on argument 1 and Ms. Pena has me on argument 2. And there's also a question about sort of how we order things. I would make a change so that we're ordering dismissal now without prejudice with a further order to reimburse, with the understanding that if payment is not forthcoming, protestants can file a motion for rehearing. So that's how I might tweak this order a little bit. And that's where I come down on the arguments we've heard. Commissioner Janeka.
I'm comfortable with that.
Commissioner Gonzalez.
I'm also in agreement.
All right. Well, let me offer a motion and then we can discuss it on the other side if we need to. Colleagues, I move that we adopt the ALJ's proposed order dismissing without prejudice the application of USA Waste of Texas Landfills Incorporated for MSW permit number 2185A with the following amendments. 1, replace ordering provision number 1 with the following, quote, the application of USA Waste of Texas Landfills Incorporated for MSW permit number 2185A is hereby dismissed without prejudice. 2, add ordering provision number 1A to state, quote, in accordance with 30 Texas Administrative Code section 80.25, applicant shall pay costs incurred by the parties in the following amounts. Harris County, $207,623.30. Hope Healing and Hooves, $5,158.14. And West Wind Industries, $416,535.36. I further move that to accurately state the reimbursement amount that West Wind Industries proved before issuance of the ALJ's proposal for decision and proposed order, correct finding of fact number 9 to state, quote, West Wind Industries expenses, not including attorney's fees, that it incurred in the permitting process for the application total $4,000, let me try this again. $416,535.36, end quote. And that's the end of my motion. Is there a second?
I second that motion.
Okay. Any discussion? All right. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the petition by Circle S Midlothian LLC for the creation of Circle S West Municipal Utility District of Ellis County. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Colleagues, Ellis County, as they've done before, has raised relevant concerns connected to its statutory authority in this matter. These concerns include issues relating to water quality, groundwater, and subsidence. The proposed district is entirely within the county. I would grant the request.
I agree.
I agree.
I would move that we grant the hearing request of Ellis County and refer the matter to SOA for a contested case hearing on the petition.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the application by Thomas Howard Watson II for renewal of air quality permit number 106325. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Colleagues, as you're aware, this is a no increase renewal, but because the applicant's compliance history classification is unsatisfactory, there can be a right to a hearing under Texas Health and Safety Code, section 385.0560. Moreover, the requester has met both the procedural and substantive requirements to be entitled to a hearing, including residing within 440 yards of the facility. So I would grant the request on the concerns raised, those being nuisance dust and compliance history. Commissioner Janeka.
I agree.
Also agree. You ready for
I
a
think
motion?
we're ready for a motion.
I move that we find that there's a right to a hearing on this application pursuant to Texas Health and Safety Code, Section 382.056, that we grant the hearing request of Thelma Rogers, and that we refer the application to SOA for contested case hearing on the following issues. A, whether the draft permit contains adequate conditions to protect against nuisance dust conditions during operations, and B, whether the applicant's compliance history raises any issues regarding the applicant's ability to comply with the material terms of the permit that warrant denying or altering the terms of the draft permit, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we set a maximum hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration of an application by FNH Construction LLC for issuance of air quality standard permit for concrete batch plant registration number 173515. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
So colleagues, neither of the two requesters reside within 440 yards of the facility, so we cannot grant these requests. I would also deny the request for reconsideration. The Spanish language newspaper that was used is a publication of general circulation in the county, meeting the requirements of Texas Health and Safety Code, Section 382.056A. Concerning the executive order, it applies only to federal agencies, not to state agencies. Moreover, the protectiveness was determined under applicable law without regard to race or socioeconomic status in the surrounding community. There is no discrimination. Finally, the location of the facility relative to Cloverhill and West Simonds was adequately described, in my view. Commissioner Janeka.
I am in agreement.
Commissioner Gonzalez.
Also agree.
I think we're ready for a motion.
I move that we deny all hearing requests and the request for reconsideration, that we issue air quality standard permit for concrete batch plant registration number 173515 to FNH Construction LLC as recommended by the executive director, and that we adopt the executive director's response to comments.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call item 6.
Item 6 is the consideration of an application by Prairie Crossing Wastewater LLC for major amendment to TPDES permit number WQ00158500001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
So colleagues, there's a question here about whether the hearing request was timely, but I don't think we need to reach that as there were no timely comments. Without timely comments, there's no right to a hearing. So I would deny the hearing request. As for the request for reconsideration, I didn't find any new factual allegation that would provide a sufficient basis for remand.
I'm in agreement.
Also agree.
Ready for a motion?
I move that we deny all hearing requests and requests for reconsideration, that we issue the major amendment to the Texas Pollutant Discharge Permit number WQ00158500001 as recommended by the executive director, and that we adopt the executive director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 7 is the consideration of gifts and donations of $500 or more in value given to the TCEQ and submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning the acceptance of gifts and donations by state agencies. The Executive Director staff is here to present this item.
Good morning, Ms. Tran.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations the agency has received in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully request your acknowledgement of these gifts. As always, I'm available to answer any questions you may have.
Thank you. Colleagues, any questions? Ms. Smith, is anybody signed in to speak?
No one is signed in.
Mr. Arthur.
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval of the resolution acknowledging acceptance of gifts and donations as presented by the ED.
I do too. Greatly appreciate the gifts and support of our programs. I'm ready to acknowledge acceptance.
Likewise, except that I can't help but look at some of the wonderful travel and training experiences our agencies participate in, supported by, in some instances, our federal partners. And I regret now seeing that some of these agencies have gobbled up some of our capable and competent staff here. So I've got some mixed feelings about continuing to accept the gift, but I think it's appropriate today. Do I need to make a motion? I move that we approve issuance of the resolution with revised Exhibit A, acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated August 30th, 2024, docket number 2024-1149-MIS.
Second.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 8 is the consideration of the annual review of financial assurance mechanisms and cost estimates for radioactive material license number RO04100 held by Waste Control Specialists. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners. On behalf of the Executive Director, I'm Chance Gooden, with the Radioactive Materials Division. Available online is Ms. Carol's catching. In compliance with 30 Texas Administrative Code. Excuse me, I'll start over. Good morning, Chairman, Commissioners, and General Counsel. On behalf of the Executive Director, I'm Chance Gooden with the Radioactive Materials Division. Available online is Ms. Carol Catchings with the Environmental Law Division. In compliance with 30 Texas Administrative Code, Section 336, 736C, Waste Control Specialist financial assurance mechanisms and cost estimates are reviewed annually by the Commission at an open meeting to ensure that the sufficient funds are available for completion of the low-level radioactive waste disposal site closure plan. Included in your backup materials is the radioactive material license financial assurance summary for Waste Control Specialists for your review and approval. Thank you for your consideration. We are available to answer any questions you may have.
Thank you, Mr. Gooden. Colleagues, any questions? All right. Thank you, sir. Ms. Smith, has anybody signed in to speak?
No one is signed in.
Mr. Arthur.
OPIC supports approval of Waste Control Specialists financial assurance mechanisms and cost estimates as recommended by the ED.
Thank you. Colleagues, these bonds appear to be appropriate both in terms of amount and form, and the cost estimates appear to me to be appropriate as well. I'm ready to move forward.
I'm as well. It just occurred to me, I thought I had one question for Executive Director staff, if we might indulge us on it. And I'd like to ask Mr. Goodwin, in terms of the state's resources available for cleanup of sites like this facility elsewhere in the state, is this the extent of resources available to Texas if we needed to clean up and decommission the site facility?
Sure. So it's adjusted based on what it looks like the green light's on. I apologize for that. So yeah, it's based on what the receipts and disposal activities that are going on at any given year. It happens day, week, month. So it's a constant number. And so the surety bonds are based on that level of activity that's going on for anything that's constructed and operated today.
Can you, I'll be more transparent in my leading question. Can you mention the environmental perpetual radiation care account for the state and just comment how that sits as a resource for our agency separate from this fund that we're talking about today and the financial assurance? Sorry, just kidding. Never mind. And thank you for not straying from the posted items for the public. I'll just say I appreciate the thought that goes into this particular piece that we come up to our agenda and check in annually on to ensure that it's sufficient. The reviews are still robust and thorough there, but I'm also thoroughly comforted by the fact that the state has a variety of different instruments to provide backstops against cleanups for these types of sites and facilities if they are ever necessary, as they rarely are, but it's important when they're necessary. So I'm ready to move forward today. Thank you all for indulging me. Sorry again for
Thank you.
getting close to the edge. Thanks, Ms. Smith.
It is so tempting and so easy to stray outside the noticed issue just because this is interesting work. The work we do, I think it's really fascinating. So I find myself biting my tongue frequently. Ms. Smith, has anybody signed in to speak on this item?
No one signed in.
Mr. Arthur.
So Chairman, we support approval of the Waste Control Specialist financial assurance mechanisms and cost estimates as recommended by the ED.
I feel like we've already done this. Deja vu. I apologize. Where are we?
Would you like a motion?
Let's have a motion, please.
I move that we approve Waste Control Specialist financial assurance mechanisms and cost estimates as recommended by the Executive Director.
I second the motion.
Thanks. I want to thank Public Interest Council for their redundancy for really driving the point. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 9 is the consideration of the Executive Director's air target risk level policy, which proposes to set a target cancer risk level of 1 in 100,000 for developing screening levels that are used in TCEQ's air permitting program and that are compared to ambient air monitoring data. The Executive Director's staff is here to present this item.
Good morning, Dr. Lang.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Dr. Sabina Lang, and I am the Chief Toxicologist at the TCEQ. I'm appearing here this morning on behalf of the Executive Director. With me is Tammy Mitchell from the Office of Legal Services. The Executive Director has completed a policy to use a target cancer risk level of 1 in 100,000, or 1 × 10⁻⁵, for setting screening levels that are used in TCEQ's air permitting program and for comparison to air monitoring data. The Air Target Risk Level Policy implements the Sunset Advisory Commission's Management Action Recommendation 1.2 detailed in that commission's staff report. A target cancer risk level represents the increased probability of an individual's cancer risk from a lifetime exposure to a chemical that can cause cancer, also called a carcinogen. A target risk level is set to confer no significant increased risk of developing cancer. These risk levels are set by policymakers and risk managers as a necessary step in the risk-based decision-making process of developing cleanup levels, which determine what concentrations of chemicals must be removed or cleaned up from a contaminated site, and when developing screening levels, which determine what concentrations of chemicals require additional investigation when encountered. Based on this target risk level, the risk assessor can then establish the corresponding long-term health protective concentration of a chemical in a given environmental media, such as soil, air, or water. In the late 1980s and early 1990s, the U.S. Environmental Protection Agency addressed target cancer risk levels in multiple rulemakings. They described an acceptable lifetime cancer risk range of 1 in a million to 1 in 10,000 in their National Contingency Plan, which applies to the Superfund program, and in their national emission standards for hazardous air pollutants for benzene. When deciding an acceptable cancer risk for benzene in the latter rulemaking, EPA chose a risk of 1 in 10,000 for that individual chemical. Multiple TCEQ programs have chosen a target cancer risk level for individual chemicals of 1 in 100,000, which is a cancer risk that is 10 times lower than the top of EPA's acceptable cancer risk range. The TCEQ's Texas Surface Water Quality Standards adopted the 1 in 100,000 target risk level in 1999, in 1991. And the Texas Risk Reduction Program rule for site remediation adopted it in 1999. The same risk level has been applied since 2006 when setting screening levels for use with the air permitting program and for comparison to air monitoring data, but its use for these air programs was not specifically discussed by the Commission. On August 16th, 2023, the Commission approved a request to post the proposal for this policy for 30 days of public comment. The comment period was open from September 1st to October 2nd, 2023. 7 unique sets of public comments were received, and the responses to these comments are provided in the backup materials in the form of a technical response and a plain language response in both English and Spanish. The Executive Director respectfully requests that you adopt the air target risk level policy. In addition, the Executive Director requests permission to publish the responses to comments and the final policy document in the Texas Register, and also to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you for your consideration, and we are available to answer any questions you may have.
Thank you, Dr. Lang. I have none. Any questions, colleagues? Seeing none, Ms. Smith, has anybody signed in to speak?
No one has signed in.
Mr. Arthur.
OPIC recognizes and appreciates the public's interest in this project. We also recognize and appreciate the staff's work on this project. We have considered the backup materials, including Sunset Recommendation 1.2, and public comments and responses addressing target risk levels, cumulative cancer risk, overburdened communities, background cancer risk, childhood exposure, and non-cancer health effects. On balance, OPIC supports adoption of the ED's air target risk level policy.
Thank you. Colleagues, we've had really a long-standing practice and policy of using this target risk level. I don't see any reason to change. Appreciate Dr. Lang's comments, putting this risk level, this policy in context of EPA's policy that has a floor of 1 in 10,000, which is 10 times less stringent than what we had before us, what's proposed. All that is to say, I like this. I'm ready to move forward. Commissioner Janeka.
I too am in agreement, and I'll only add one point that I'm grateful for the sunset review process and highlighting this as a necessary piece to bring up to our commission level and allow the public to see and engage and respond to it up in this level of our agency's operation. I think it's a worthwhile engagement. This exercise, the first time we've done it in response to that sunset comment, I think helps us recognize years of good work that toxicology is putting into where to set reasonable and appropriate levels for all the different chemicals we work with and regulate. And I'm grateful to see that work moved up to this point. I don't consider that criticism or that constructive criticism from Sunset a negative critique of our process, and I'm grateful for it.
All right. You baited me. I need to add some comments. Totally agree that this is appropriately before us. The commissioners should be weighing in on this. I'm with you there. The idea that things that don't come to the commission lack transparency, I don't buy it for a second. We have tremendous public process for things that I hope, I don't mean to sound harsh, but we have a lot of public process for things that don't come before the commission. I know in connection with, well, Ms. Smith is going to kick me in a second, but I'm going to finish the thought. We frequently have peer review, public comment session, early engagement in the process, written responses to comments on policies adopted by the executive director that don't come to us. So just because it doesn't come to us does not mean that we haven't had a fulsome peer review, public comment, response to comment sort of process. So, I'm glad to get that off my chest. Thank you, Commissioner.
Thank you for adding that. I fully agree.
Commissioner Gonzalez.
I'm going to say less, just it's obvious that a lot of thought and work went into these, and I appreciate it. Thank you.
That is a wise commissioner. Thank you. All right.
I move that we approve the target cancer risk level of 1 in 100,000 as recommended by the executive director.
Second that.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 10 is the discussion of the agency's fiscal year 2026 and 2027 legislative appropriations request, and the executive director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Janae Burse, Deputy Director of the Budget and Planning Division, and I'm here to present a brief report to you on the final version of the Legislative Appropriation Request, or LAR, for fiscal years 2026 and 2027. The LAR was filed on September 6th and contained a request for 6 exceptional items totaling $115,132,522. This is a decrease of $683,546 from the amount approved by the Commission. I have filed an updated overview of the exceptional items for your review. The new amounts are reflected on the second page, which was page 4 of the original packet. So the page numbering is to correspond to the original packet. The reason for the difference was a revised cost estimate for the data center services exceptional item. That particular exceptional item was reduced by $533,677 for the biennium. We believe the filed version contains the most accurate estimate of needs. The other difference between the presented and the filed versions were primarily due to the calculation of staffing costs and the 1.5% payroll cost. The next step in the process is a public hearing on October 4th at 1 p.m. in the Capitol Extension Room E2014. The agency will present an overview of its LAR and exceptional items, and public testimony will be taken. Thank you. I'm available for questions.
Thank you, Ms. Pierce. Colleagues, any questions? All right, Ms. Smith, has anybody signed in to speak?
No one has signed in to speak. There are people signed in to listen, but didn't ask to address the commission.
All right, thank you. Mr. Arthur?
OPIC has no comment except to say that we appreciate the updated information.
Thank you. Appreciate the correction. Colleagues, there's no action necessary on this item, so Ms. Smith, I'll ask you to please call the next item.
That takes us to our enforcement docket, which are items 11 through 29, and the executive director staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Melissa Cordell and Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 11 through 29. The total assessed administrative penalties are $666,742, with $49,057 deferred, $347,747 applied towards supplemental environmental projects, and $269,938 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I have none. Any questions, colleagues? Ms. Smith, has anybody signed in to speak?
We have someone available on item 13 if the commission has questions, but nobody's asked to address the commission.
Thank you, Mr. Arthur.
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Colleagues, I do as well. Commissioner Janeka?
I'm willing to move forward. I've got a motion.
I move that we adopt items 11 through 29 as recommended today by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item 30 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sotomayor of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through July. There were 812 effective administrative orders issued, and of those, 144 contained supplemental environmental projects. These orders assessed a total of $12,695,907 with a payable amount of $5,787,384. $5,303,365 are to be paid towards supplemental environmental projects. 13,601 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,814 enforcement action referrals have been received. There are 3,133 pending administrative orders with 1,483 cases that are on the backlog. 145 cases are pending at the Attorney General's office for representation in district court, and 9 judgments have been issued. 1,227 cases are being tracked for compliance. We're available to answer any questions you may have.
Thank you, Ms. Sotomayor. I have none. Any questions, colleagues?
No questions other than the comment that I'm pleased to see the SEP data point line pulling up ahead above the past years at this point.
Thank you. Ms. Smith, is anybody signed in to speak?
No one has signed in.
Mr. Arthur?
OPIC has no comment except to say that we appreciate staff's report.
Thank you for the report. We appreciate it. Colleagues, no action is necessary on this item. So Ms. Smith, I'll ask you to please call the next item.
Item 31 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 321, regarding the control of certain activities by rule, and Chapter 210, the use of reclaimed water for legislative implementation. The Executive Director's staff is here to present this item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Erica Crespo with the Water Quality Division. With me here today is Robert Sadler with the Water Quality Division, and virtually is Michael Parr with the Environmental Law Division, This proposed rulemaking will implement Texas Water Code changes that were brought about by Senate Bill 1289 during the 88th legislative session. The rulemaking will amend Title 30 of the The rulemaking will amend the Reclaimed Water Production Facility rules of Title 30 of the Texas Administrative Code, Chapter 321, Subchapter P, as well as the use of reclaimed water rules in 30 Tax Chapter 210 to allow for the authorized means of disposal and alternative means of disposal of any unused domestic reclaimed water through the collection system of an associated wastewater treatment facility without the requirement of a permit. In order to do this, the owners of the reclaimed water production facility must obtain consent from the owners and operators of the associated wastewater treatment facility and collection system. Staff in the Water Quality Division initiated rule text changes to implement and enforce the Texas Water Code statute changes, and we also included additional changes that we believe are necessary to ensure readability and improve clarity of the rule revisions. We respectfully request publication of this proposed rulemaking in the Texas Register. Thank you, and we're available to answer any questions.
Thank you, Ms. Crespo. I have no questions. Colleagues, any questions? Seeing none, Ms. Smith, is anybody signed in to speak?
No one has signed in on this item.
And what's the view from the Public Interest Counsel's office?
Thank you, Chairman. Good morning, Commissioners, General Counsel, ED staff. We've reviewed the rule proposal package and we support publication. As she laid out very well, this is a legislatively mandated effort that has the potential to encourage reclamation of water in Texas. It would change the rules that apply to reclaimed water production facilities to allow those facilities to dispose of unused reclaimed water without additional permits for alternative means of disposal. They would have to get consent from the owner of both the wastewater treatment collection system and the facility that would further treat the reclaimed water. Any wastewater treatment system or facility that agrees to receive or treat the reclaimed water may incur additional costs for construction or operation. Additionally, the temporary costs of construction of additional reclaimed water production facilities, which is encouraged by this rulemaking, could be passed along to the consumer. However, an increase in reclaimed water would grow the water supply in Texas, and particularly during times of high demand, this would hopefully lead to lower water costs for all Texans. We note that the public involvement plan and alternative language requirements have been properly proposed, and we will be attending the hybrid public hearing that will take place on November 8th. As always, we will monitor this effort as it progresses and keep the commission apprised of any public interest issues that may emerge. And we appreciate staff's hard work on this, and we support publication. Thank you.
Thank you. Colleagues, for all the reasons we've heard, I also support publication.
Well said. I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code Chapters 321 and 210 as recommended by the Executive Director.
Second that.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
Items 32 through 35 are for closed session, but the commission will not be meeting in closed session today.
The time is 10:48. We are adjourned.